Welcome to the McDowell County Schools Annual Employee Policy Training and Review. Today we will look at policies and procedures as listed on your screen. Please remember, in the time allowed, there is no way to go over the full versions of all the policies. This presentation is just an overview. You can always visit the McDowell County Schools website or State Department of Education's website for the full version of policies. Now let's take a look at the mandate to report. If you take a look at the list on your screen, those in red are particularly our employees that are mandatory reporters. Of course, everyone listed on the screen are also mandatory reporters according to West Virginia Code. When and who are mandatory reporters? Mandatory reporters shall immediately and not more than 24 hours report to DHHR. Required direct reporting by an individual who received disclosure or suspects abuse. Reporting to a supervisor does not exempt a person from this mandate. Students might share with you three different types of disclosures: indirect hints, disguised disclosures, disclosures with strings attached. How do you make a report? Simply call the number to the West Virginia Child Abuse Neglect Hotline on your screen. For serious physical abuse or sexual abuse, please also contact the state police and local law enforcement. You should contact CPS whenever you reasonably suspect abuse. CPS will accept your report and determine if the child is safe or needs protection. What will CPS ask when you make a report? They might ask family demographics, the alleged abuse or neglect, specific caregiver information, events or circumstances related to the abuse or neglect, the effects. They also might ask you some general information, including the condition or function of the child, the location, the state of mind, or emotions and fears of the child, proximity of threat, and access to those who can help and protect. What will CPS ask when you make a report? They might ask you additional information particular to the caregiver, as listed on your screen. It is important to note that House Bill 2939 requires mandatory reporting of sexual offenses on public school premises involving or between students. This requirement has been set in place in addition to the mandatory reporter provisions that are already part of law. A person or official or institution required to report a case involving a child known or suspected to be sexually assaulted or abused, or a student known or suspected to have been a victim of any non-consensual sexual contact, intercourse, or intrusion, who knowingly fails to do so or knowingly prevents another person acting reasonably from doing so, is guilty of a misdemeanor punishable by not more than 6 months in jail and or a fine not more than $10,000 according to West Virginia Code. Teachers and other personnel do not have to report learning from a witness or personally observing consensual sexual contact, intercourse, or intrusion occurring between students unless the act involved contains one of the following: forcible compulsion, the infliction of serious bodily injury, employing a deadly weapon, sexual intercourse or intrusion of a student who is mentally disabled, a student 16 years old or older engaging in sexual intercourse or sexual intrusion with a student under the age of 16 who is not his or her spouse and is 4 or more years younger, a student 14 years old or making sexual contact with a student who is younger than 12. Finally, sexual contact with a student who is physically helpless. Let's take a look now at the drug-free workplace. All employees have signed a drug-free workplace verification statement. The following shall be considered prohibited conduct. 1. No employee shall unlawfully manufacture, distribute, possess, or use illegal drugs or medically non-prescribed controlled substances and or alcohol. The reporting to work under the influence of illegal drugs, non-medically prescribed controlled substance, intoxicant, look-alike drugs or alcohol, or possession of non-medically prescribed paraphernalia is prohibited. No employee shall report for duty or remain on duty while having an alcohol concentration of 0.04 or greater. No employee shall report for duty or remain on duty while abusing legal, prescription, or over-the-counter drugs or alcohol or using illegal drugs. No employee shall consume or possess open containers of alcohol on board property, in the Board of Education vehicle or vehicles rented by the Board of Education. No employee shall refuse to submit to a post-accident reasonable suspicion, return to duty, or follow-up alcohol or drug test as applicable. No employee shall report for duty or remain on duty when the employee uses any controlled substance, except when the use is pursuant to the instruction of a physician, who has advised the employee that the substance does not adversely affect the employee's ability to perform assigned duties. If an employee engages in the prohibited conduct as a result of the misuse or abuse of legal medications and or the use of illegal drugs, non-medically prescribed controlled substances, intoxicants, look-alike drugs or alcohol, and otherwise violated the terms of this policy, the employee shall be deemed unqualified to perform his or her duties and shall be immediately removed from the assignment in order to protect the policy, safety, and welfare of students and adults in the school environment. The removal will constitute a paid or unpaid suspension at the discretion of the superintendent and local board. If an employee violates any portion of a testing facility's protocol for obtaining a sample from the employee, which protocol has been explained to the employee orally and or otherwise, the employee shall be deemed unqualified to perform his or her assigned duties and shall be immediately removed from his or her assignment in order to protect the health, safety, and welfare of students and adults on the school environment. Consequences and other information may be found in the complete policy at the URL listed on your screen. The McKinney-Vento Homeless Assistance Act. Unaccompanied children and youth. Those students who experience homelessness are defined as children and youth who lack a fixed, regular, and adequate nighttime residence, and can include those who are sharing housing or doubled up due to economic hardship, living in motels, hotels, trailer parks, campgrounds, living in emergency shelters or abandoned in hospitals. Those who have a primary nighttime residence that is public or private that's not designated for ordinarily sleeping. Living in cars, parks, abandoned buildings, substandard housing, bus or train stations, or public spaces. Also, those children who are migratory, living in above circumstances. Our students who are homeless under the McKinney-Vento Act have educational rights. They have the right to go to school no matter where they live and how long they've lived there. Attend either the local school or the school of origin, if this is in their best interest. The school of origin is the school the child was last enrolled in. Receive transportation to and from the school of origin. Enroll in school immediately even if records are missing, such as birth certificates and proof of residence. Enroll, attend classes, and participate fully in all other school-related activities. Have access to the same programs and services of students who are not experiencing homelessness. Maintaining the security and privacy of student data, also known as FERPA. You have access to data tools that allow you to view individual student records for performing your official duties. You are legally and ethically obliged to safeguard those records. The purpose of this presentation is to inform you of your responsibilities in protecting students' privacy. What are your responsibilities? You must protect the privacy and the confidentiality of student data, comply with state and federal laws and district policies, use confidential student data only as necessary for legitimate educational purposes, and always please keep your passwords confidential. Consequences. Student education data may not be released except under specific circumstances. Improper release of data exposes you and your district to potential criminal and civil liability, and ultimately the loss of federal funding. Student-specific information gathered from secure tools may be shared only with authorized school personnel. Protection. Be careful to prevent unauthorized people from viewing your screen while you're accessing student information. When you are finished with your data tools online, log off and close any windows containing data or reports. Sharing of reports. Printed reports can be shared publicly only after you review them to ensure that no student can be identified from the report. If a reasonable person from your community could identify a student from the report, directly or indirectly, then you should store that report in a secure place. FERPA. What is FERPA? FERPA is known as the Family Educational Rights and Privacy Act of 1974. FERPA are federal regulations that govern access to the release of personally identifiable information found in student records. It applies to all schools that receive funds under applicable programs of the Department of Ed. It does not apply to private schools whose students or teachers receive services from the local board or state education association, unless the private school also receives federal funding. Purposes of FERPA. Access to educational records for parents and students. FERPA affords parents the right to have access to their child's educational records, to seek to have their records amended, and consent to the disclosure of personally identifiable information from education records except as provided by law. For authorized representatives, to limit on disclosure, prior written consent, and consent exceptions. Directory information. Information in an educational record of a student that would not generally be considered harmful or an invasion of privacy if disclosed. As defined in Policy 4350, directory information can include the following: Additionally, McDowell County Schools forwards educational records, including transcripts, to other agencies or institutions which the student seeks or intends to enroll, without prior consent of parents. Also, McDowell County Schools can share personally identifiable information with other school officials with legitimate educational interests, with another school at which the student intends to enroll, with other state or local educational agencies and authorities for auditing and evaluations. Also, McDowell County Schools can share personally identifiable information about students if the school district has designated the information as directory information. Please let's make it clear that directory information is not a child's social security number or a student's WEBIS ID. Student record information. Educations are directly related to the student and maintained by the Educational Association or institution or by a third party acting for the agency or institution. Student records may be disclosed to the student without proper authentication. FERPA requires the use of reasonable methods to determine the identity or intended and authorized recipient of information and authenticate or ensure that the recipient is in fact who or she proposes to be. Parent access procedures. Parents have the access and right to inspect and review, a 45-day timeline to provide records, and they may charge reasonable fees for copies but not to search or retrieve. Exceptions. Letters of recommendation for which the student has waived the right to review. Information about other students. Personally identifiable information. Student's name, parents or family member's name, student's address, and other information that would allow a reasonable person in the school or community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable certainty. Indirect identifiers such as date and place of birth and mother's maiden name. Other information that alone or in combination is linked or linkable to a specific student that would allow a reasonable person in the school community who does not have personal knowledge of the relevant circumstances to identify the student with reasonable accuracy. Reasonable methods. Regulations require the use of reasonable methods to ensure access is only given to those with legitimate educational interest. Reasonable methods could include physical control, technological control, administrative policies. This also means no student data is transferred off-site using portable media, such as thumb drives, or sent via email unless it is a password-protected file. FERPA and HIPAA. At the elementary or secondary school level, students' immunization and other health records that are maintained by a school district or individual school, including a school-operated health clinic that receive funds under any program administered by the U.S. Department of Education, are education records subject to FERPA, including health and medical records maintained by a school nurse who is employed by or under contract with a school or school district. What can and cannot be released. Individual student data can never be publicly published or released. Summary that's aggregated data can be released, but only if the group size is large enough to protect the privacy of individual students. When the identity of an individual student could be inferred due to a small group size, treat that report as confidential. The summary reports to which you have access may contain small group sizes and should therefore be treated as confidential. Disability, harassment, discrimination, and student employees. Discrimination is prohibited. McDowell schools in the West Virginia Department of Education do not discriminate on the basis of sex, race, color, national origin, religion, disability, gender, sexual orientation, and age, employment, and in the administration of any of its educational programs and activities. Harassment and discrimination, what is it? It's unwanted and unwelcome. Conduct or communication that has the purpose or effect of substantially or unreasonably interfering with an individual's employment or education, or creating an intimidating, hostile, or offensive employment or educational environment. Harassment and/or discrimination are illegal under the Civil Rights Act of 1964, as amended, Title IX of the Education Amendment of 1972, and Section 504 of the Rehabilitation Act of 1973 for students and employees. Harassment or violent procedures for reporting, investigating incidents of racial, sexual, religious, ethnic disabilities. School personnel are required to 1. Report an incident to their immediate supervisor, and 2. Submit a written report to the incident including the person's name, complaint, date, time, location, and etc. to their immediate supervisor, and the immediate supervisor will log the report the same day with the superintendent of schools and/or designee. Students are required to report an incident to their teacher and/or principal, and provide a written report detailing the incident to their principal. The principal shall take immediate steps to protect the complainant, pupils, teachers, administrators, and/or other personnel pending completion of an investigation of religious, ethnic, racial, sexual, disabilities, harassment, or violence. The result of the investigation of each complaint filed under these procedures will be reported in writing to the complainant and/or his/her legal guardian. Sexual harassment is defined as quid pro quo harassment, conditioning any educational opportunity or benefit on the granting of sexual favors. Any form of sexual assault, dating violence, domestic violence, or stalking. Unwelcome conduct of a sexual nature that is so serious, pervasive, or objectively offensive that it effectively denies a person equal access to an educational program determined under a reasonable person standard. Actual knowledge. A school district has actual knowledge when any employee knows of sexual harassment. An employee employee knows of sexual harassment when they have observed it or have heard of it. Notice to a Title IX coordinator or an official with authority to institute corrective measures is actual knowledge. Any employee who has observed or heard of the sexual harassment has to report the harassment to their supervisor or Title IX coordinator within 24 hours. Supportive measures. The Title IX coordinator is to offer supportive measures to the complainant or respondent upon the receipt of the report of the alleged sexual harassment. The supportive measures are offered to either party. Supportive measures are non-disciplinary, non-punitive, individualized services as appropriate, reasonably available, and without fee or charge. Examples of supportive measures are counseling, adjustments to schedules, mutual restriction, and contact between parties, and increased monitoring. A formal complaint. The complainant has the right to the informal resolution process and also has the right to file a formal complaint. Upon receipt of the complaint, the school district shall investigate. The district can dismiss a formal complaint if the conduct does not meet the definition of sexual harassment. If the investigation is undertaken, the district-assigned investigator will collect the evidence within the timeline of the policy and provide the investigative report fairly summarizing relevant evidence to the decision maker. The decision maker will then review the investigative report and inform both parties of the decision by providing written determination of responsibility to both parties, in accordance with policy requirements, providing any remedies if applicable. Appeals. Both parties can file an appeal following the determination regarding responsibility on the following basis. Procedural regularity. New evidence. The Title IX coordinator, investigators, or decision makers had a conflict or an interest or bias for against the complainants or respondents. Now we'll move into the Employee Code of Conduct. All employees shall exhibit professional behavior by showing positive examples of preparedness, communication, fairness, punctuality, attendance, language, and appearance. Contribute, cooperate, and participate in creating an environment in which all employees and students are accepted and are provided the opportunity to achieve at the highest levels in all areas of development. All employees shall maintain a safe and healthy environment, free from harassment, intimidation, bullying, substance abuse, and/or violence, and free from bias and discrimination. All employees shall create a culture of caring through understanding and support. Employees shall immediately intervene in any code of conduct violation that has a negative impact on students in a manner that preserves confidentiality and the dignity of each person. Demonstrate responsible citizenship by maintaining a high standard of conduct, self-control, and moral ethical behavior. And of course, comply with all federal and West Virginia laws, policies, regulations, and procedures. Inappropriate physical and emotional boundaries. Behavior between educators and students must serve a demonstrated educational, health, or safety purpose. There should always be firm boundaries between an educator and students. Even taking into consideration pre-existing and familiar relationships, impropriety, and favoritism can still occur. The following items should be of concern, especially when they occur in secret, without the knowledge of administrators and/or parents. Level 1. Taking an undue interest in a particular student. Favoring certain students by giving them special privileges or status, performing personal errands for educators unrelated to any educational purpose. Inviting or allowing certain students to come to the classroom at non-class times. Getting a particular student out of class to visit the teacher during the teacher's planning and prep period. Engaging in peer-like behavior with students. Level 2. Using poor judgment regarding a particular student. Allowing students to address the educator in non-professional ways, their first name, nicknames, pet names. Allowing students to get away with clear inappropriate behavior. Being alone with a student behind closed doors at school out of view of others. Exchanging gifts, cards, or money with a particular student. Being overly touchy with certain students, teaching students for no educational or health reason. Giving students rides in the educator's personally owned vehicle, especially alone. Frequent electronic communication or phone contact with a particular student. Level 3, personal life involvement. Talking to the student about the educator's personal problems and issues, or talking to the student about the student's personal problems and issues. Initiating or extending contact with students beyond the school day. Taking a particular student on outings, especially personal outings, away from protective adults. Using personal or internet communications to discuss personal topics or interests with students. Being connected to a student via social media platforms outside of athletics or school accounts. That is, if you are connected with a student via social media such as Snapchat, Whisper, WhatsApp, GroupMe, Telegram, Instagram, Facebook, Messenger, Twitter, Kik, and more. Level 4, not respecting normal boundaries, especially if uninvited, unwelcomed. Invading the student's physical privacy, that is, walking in on the student in the bathroom or changing room. Inviting students to your home. Visiting the student's home without the presence of parents or guardians. Asking the student to keep certain things secret. Socializing where students are consuming tobacco, alcohol, or drugs. Level 5, sexually related conduct, especially if uninvited, unwelcomed. Engaging in sex talks with students, innuendos, bantering, or jokes. Talking with a student about sexual topics that are not related to a specific curriculum. Showing or sending pornography to the student. Hugging, kissing, or other affectionate physical contact with the student. Inappropriate physical and emotional boundaries. Many of these behaviors are acceptable between consenting peers. However, educators and students are not peers. There is no place for peer-like behavior between educators and students. The more of each specific violation that occurs between an educator and a student, the more frequently the violations occur between an educator and a student, and when they occur in secret, the risk increases that the educator is sexually grooming the student. If so, physical, sexual, or romantic contact may occur or has occurred. Electronic communication guidelines. Staff, both professional and service personnel, may bring a personal cell phone or device to work. However, they are not to be utilized by staff when engaged in the supervision of students. Misuse of cell phones or devices will result in disciplinary action. Bus operators are prohibited from the use of cell phones or any personal device while operating a school bus, whether or not students are present. If communication with the transportation department is absolutely necessary, the operator must bring the bus to a complete stop in a safe area. This policy does not prohibit any device used for medical purposes that is worn by an employee because of a condition that requires its use. The employee must have on file with the supervisor a signed statement from a licensed physician. This policy does not prohibit the use of a personal device to manage calendars, set reminders, make work-related calls, or utilize productivity apps. However, county-issued devices are to be used for programs and apps such as Class Dojo. Employees are personally and solely responsible for the care and security of their own devices. The board assumes no responsibility for theft, loss, or damage, or misuse or unauthorized use of a device that is brought onto the McDowell County Board of Education property. Now we'll study the performance evaluation of school personnel. The key purposes of the revised West Virginia Educator Evaluation System are to set high standards for both veteran and new teachers, ensure high-quality instruction focused on student achievement, and encourage continuous growth. The evaluation also includes 2 performance standards that evaluate outcomes and other essential aspects of professional teaching. Performance standards. On your screen, you will see standards 1 through 5. And here are standards 6 through 7. In order to be a manageable, effective evaluation system, each standard has elements. The standards have a total of 16 critical standard elements. Please notice the evaluation system timeline. The timeline begins October 1, and as you can tell, progresses throughout the school year, prior to the last day for teachers, but not later than June 15th. We encourage you to take a look at the policy and the levels of performance in the educator evaluation system. As you can tell, there are different levels of performance, from unsatisfactory, progressing to distinguished. The observation cycle. Evaluators record data on the observation form. The educators complete evidence form within 5 days. Then the evaluators conduct a conference within 10 days of the observation. All teachers and counselors shall participate in an annual summative evaluation conference on or before the teacher's final day in the classroom for the school year, or on or before June 15th of the school year, whichever occurs first. The evaluation is recorded on the online system. On your screen, you will notice the different progressions for goal setting. In initial years 1 through 3, to intermediate years 4 through 5, to the advanced years of 6 years or more. You will also notice on your screen the evidence and feedback required for each phase. A focused support plan should be proactive and preventative. It takes place after a purposeful conversation and when there is documented evidence indicating an area of concern. A focused support plan can happen after at least one observation is conducted. It supports and meets the individual needs. It may address an area of concern involving student learning goals when in conjunction with one or more of the 5 performance standards. School-wide student growth cannot be considered for a focused support plan. A focused support plan, after 9 weeks, will equal a decision. Success equals meeting standards. Adequate progress equals may continue the focused support plan for 9 more weeks. Inadequate progress equals evaluate and initiate a corrective action plan. Please note, educators will remain on their current progression while implementing a focused support plan. A corrective action plan, 18 weeks, but may commence at any time. Inadequate progression on the focused support plan, an evaluation shows unsatisfactory performance on one or more of the 5 performance standards. The corrective action plan may address an area of concern involving student learning goals when in conjunction with one or more of the 5 performance standards. School-wide student growth cannot be considered in a corrective action plan. Certain instances may require immediate action according to code. It may or may not be repeated. If evidence does not demonstrate adequate progress has been made at the conclusion of the 18-week period, termination for unsatisfactory performance shall ensue. Service evaluation. Evaluation shall be conducted of each service employee at least once per school year. Observations and evaluations may address any and all job performance duties as follows. employee's job performance specific to the employee's assigned job duty within his or her service personnel classification and the relevant posting, employee's level of cooperation and communication with other employees and supervisors, the employee's attendance habits, including timely reporting for work. Additional evaluations may be completed at any time during the school year. Service evaluation. The supervisor shall share the written evaluation with the employee during a scheduled conference within 5 working days after the completion of the written evaluation. The employee has the right to attach a written statement as an addendum to the evaluation. The employee shall sign the evaluation form denoting the supervisor has reviewed the evaluation with the service employee and that the employee has received a copy. The signature shall not imply that the employee is in agreement with the evaluation's comments. Refer to the full policy for specific details. Board of Risk and Insurance Management. Workers' compensation. On-the-job injuries. Employees injured at work must report the injury to their supervisor within 24 hours of the injury. The supervisor will complete an in-house incident report and submit that to the safety director. Compensation claims cannot be processed until this form is received. If an employee collects monetary payments for workers' comp fund, he or she should contact the finance office immediately to discuss the possibility of an overpayment. Return to work slips. The employee must have a return to work slip if he or she goes to the doctor the day of the injury and returns the next or is off work due to the injury. If the employee returns to work and at a later date is off work due to the injury, he or she must again submit a return to work slip before the employee is allowed to return. Supervisors, please note it is your responsibility to be informed of any time missed as a result due to an on-the-job injury. Also, you must submit with the incident report copies of witnesses' statements. This is needed before your compensation claim can be completely processed. Employee use of paid and unpaid leave time. On your screen, you will see a copy of our McDowell County Schools Employee Absence and Claim Form for personal leave. The form can be found on the McDowell County Schools website, and also your school supervisor or principal will have copies as well. Section 11.6. Willful absence from employment and/or abuse of paid leave. Any employee who is willfully absent from his or her duties without some form of approved leave shall be subject to disciplinary action. An employee who is found to have improperly exercised paid or unpaid leave shall be subject to disciplinary action up to and including termination of his or her employment. Unpaid leaves of absence for no more than 1 calendar year. The Board of Education shall comply with requirements of West Virginia and federal law with regard to unpaid leaves of absence for no more than 1 calendar year. Dock days. Employees shall not be absent from their assigned duties beyond their accrued paid leave days, except as specifically authorized by the superintendent or his or her designated representative. No employee shall be permitted to exercise a dock day unless he or she has first submitted a prior written request to exercise a dock day. Such prior written request shall be addressed and submitted to the superintendent or his or her designee no later than 12 o'clock noon the day before the proposed use of the dock day. Requests for permission to exercise a dock day submitted on or after the day of which the employee has actually exercised a dock day shall not be approved absent extraordinary circumstances of an emergency nature which excuse the failure of the employee to obtain prior permission. The superintendent may approve up to a maximum of 5 dock days total per school year for educational trips or any other reasonable cause which is not otherwise covered by policy. Violation of the dock day policy shall constitute insubordination and or willful neglect of duty within the meaning of code. Employees violating this policy are subject to disciplinary action up to and including unpaid suspensions and termination of employment. Expected behaviors in safe and supportive schools. At a minimum, schools shall establish a leadership team, establish a process to gain school-wide input in regards to climate and culture, develop school-wide priorities, analyze school climate and culture data, and make data-driven improvement decisions. At a minimum, schools shall implement school-wide plans that provide appropriate interventions to reinforce and support expected behaviors, implement programs and practices that promote youth asset development, implement comprehensive and effective intervention programs and practices, develop appropriate and reliable referral procedures, evaluate school climate and culture improvement processes, and revise as needed. Let's review Level 1 Inappropriate Behaviors. On your screen, you can see Level 2 Inappropriate Behaviors. And now here is Level 3. And finally, Level 4 Inappropriate Behaviors. We must take time to review restraints. A school employee may use a restraint in an emergency, a situation in which a student's behavior poses a threat of imminent, serious physical harm to the student or others, or serious property destruction, and includes the following limitations. Restraints shall be limited to the use of such reasonable force as is necessary to address the emergency. Procedures and maneuvers that restrict breathing, place pressure or weight on the chest, lungs, sternum, diaphragm, back, neck, or throat, or may cause physical harm are prohibited. Appropriate, intended use and utilization of mechanical restraints such as seatbelts or feeding tables when applied for their intended purpose are not prohibited. However, the application of mechanical restraints is prohibited as an intervention or consequence for an inappropriate behavior. Please take time to refer to pages 58 and 59 of West Virginia Board Policy 4373 for further guidance on restraints. Acceptable Use Policy Key Points. Please note an electronic copy of this entire policy can be found on the McDowell County website under the County Technology section. The use of the Internet is an educational privilege, not a right, and inappropriate use will result in the cancellation of those privileges. Students must have written parental consent to use the system. A parent can rescind the consent at any time, which will terminate the student's use of the technology. As educators, we will teach the responsibility to students about safe and responsible use of the Internet and network. It is our responsibility for monitoring students' use and intervening if students are using it inappropriately. It is also our responsibility to report misuse of his or her administrator or office of technology. Please understand there is no expectation of privacy. We have the right to inspect any user's virtual hard drive or files that it contains. McDowell County Schools has the right to give permission to the teachers, school administrators, and parents to review the use of McDowell County Schools tools by a student whom they think may be misusing the system. Users are advised that deleted messages and discussion forums, including all deleted messages and regularly archived, can be retrieved. Internet Firewall automatically checks all data moving between local area networks and logs sending and receiving destinations. Acceptable uses and behaviors. Please review the policy in its entirety. By signing the AUP agreement, everyone agrees to all established guidelines for unacceptable uses and behavior identified with this policy. Procedures for designated hiring and transfer of school personnel. Faculty Senate participation. A majority of the Faculty Senate may elect a committee, including a committee chair, which will be responsible for making hiring recommendations regarding classroom teachers. There are several options that include 3 individuals, which shall include a chair. Not less than 7 or more than 11 individuals, which shall include a chair. Single designee, where the designee shall have the discretion to ask up to 2 other faculty senate members to help in reviewing materials and interviewing applicants. And also, the single designee, the designee shall ask up to 2 other faculty senate members to help in reviewing materials or interviewing the applicants at the designee's discretion. All faculty senate members must have completed the Department of Education's designated or approved interview training prior to assisting. Faculty senate may vote to change their selected process at the conclusion of each school semester for the next semester. Please refer to West Virginia Board Policy 5000 for a complete review of this process. Grievance procedures. The Board of Education recognizes the need to resolve differences which may arise in the workplace. The West Virginia Legislature in Article 2, Chapter 6C of State Code has created the appropriate vehicle for such resolution of differences. Procedures, timelines, protocols, and forms may be found at the following URLs. Thank you for taking time to review the required annual policy and procedures training. For more information, as always, please visit the West Virginia Department of Education's website or our McDowell County Board of Education website for full versions of policies and law. As always, if you have any questions, please feel free to call us at the central office. Thank you.